rights and holding international organizations accountable through U.S. courts. The panel concerns the Jam case, which I first learned about from one of our panelists, Natalie Bridgman-Fields, who introduced me to another one of our panelists, Michelle Harrison, who was working on the case so that I could contribute an amicus brief for the U.S. District Court case and later sign on to one for the Supreme Court case. It has the potential not only to deliver remedies to the original plaintiffs, but also to allow other communities harmed by international organizational activities to turn to the U.S. courts, and the potential ultimately to have a disciplining effect on international organizations, encouraging activities that lead to less harm. So we're very lucky to have this distinguished panel help shed light on the Jam case, its background and implications. I'd like to introduce them briefly. Natalie Bridgman-Fields is the founder and executive director of Accountability Council, a leading global nonprofit of nearly 20 advocates working to amplify the voices of people to defend their environmental and human rights. Natalie has taught courses at Stanford Law and other law schools, was a Stanford CDBRL Fellow, is an Echoing Green Fellow, and a Draper Richards Kaplan Foundation entrepreneur. Previously, she served as a consultant on accountability for 2 international financial institutions. Earlier in her career as a lawyer at Wilson Sonsini, and through her own law office, Natalie litigated corporate human rights and environmental cases in U.S. courts. Jeffrey Fisher is a professor of law and co-director of the Supreme Court Litigation Clinic at Stanford Law School. He's a leading authority on Supreme Court practices and has argued 38 cases on the Supreme Court, ranging from criminal procedure to maritime law to civil and human rights. In 2006, the National Law Journal named Professor Fisher one of the 100 most influential lawyers in America, the youngest person on the list. In addition to his teaching and practice concerning the Supreme Court, Professor Fisher has published numerous articles on various criminal and constitutional issues, and he currently is writing a treatise on the Confrontation Clause. He also serves as special counsel to the Supreme Court and appellate practice group of Mulvaney and Myers. Before joining the Stanford faculty, he clerked for U.S. Supreme Court Justice John Paul Stevens and Judge Stephen Weinberg of the U.S. Court of Appeals for the Ninth Circuit. Michelle Harrison is a staff attorney at EarthRights International in Washington, D.C., where she focuses on litigation strategies, seeking remedies for communities suffering human rights and environmental harms by corporate actors, and legal advocacy strategies to enhance corporate accountability. She is counsel on a number of ERI's transnational cases, including Jam. Michelle is also counsel on U.S. lawsuits arising out of a banana company's financing of paramilitary death squads, a climate change accountability suit against fossil fuel companies, and has previously defended the First Amendment rights of environmental activists facing abusive retaliatory legal actions. Michelle also leads ERI's extractive industry transparency work using legal and administrative actions to advance U.S. and global disclosure frameworks and combat corruption. And finally, Kendra Moore serves as Accountability Council's policy director, leading efforts to protect environmental and human rights through accountability in international finance. Kendra brings extensive advocacy and accountability experience from working with the Office of Inspector General for the City of New Orleans, PricewaterhouseCoopers, where she worked on governance and corruption issues, the World Bank's Office of Evaluation and Suspension, the Office of U.S. Senator Russ Feingold, and Oxfam International. So I'm going to start by asking each of our panelists a question to start, hopefully we can keep answers under about 10 minutes so that we'll have a lot of time to open it up to the panel. So Natalie, I wanted to start with you. I was hoping that you could give us some background on multilateral development bank finance, specifically the IFC, and the challenges that communities have faced holding international organizations accountable for environmental and human rights harms in the past.
Sure, thank you for the invitation to be here today, Erica, for all your work organizing this panel. It's a real treat to be able to talk about this really fascinating topic which touches on so many different interdisciplinary areas, and I'm pleased to see everyone here today. Just very briefly, for those less familiar with World Bank Group. It's an international financial institution that's owned by citizens of the world. So rich countries, governments pay into it. Poor countries, governments borrow from it. That's the basic structure. But instead of one flag, one vote like the UN, it's you get what you pay for. So the U.S. owns 16% of the shares in the World Bank and has then 16% of the voice and the vote over what happens. So it's an inherently unequal, unjust system of governance. That's the first thing to note. The results of that have been very complicated and possibly predictable. So what we've seen over the last 60-some years of the World Bank's operations post-World War II, it was created to rebuild Europe. And then in the 60s, it became really an anti-poverty institution and added a couple of extra tools. But the short end of it is that now the World Bank Group has lending that it gives to governments, as well as lending that it does directly to corporations. So it has public sector and private sector arms. It also gives political risk insurance, kind of creating a perfect umbrella of security for the governments and corporations wishing to put forward big projects like dams, mines, pipelines, and a fairly risk-free environment for the investors, governments, and corporations benefiting from it. So to cut to the chase of what's happening here is that in the 70s, 80s, 90s, there were a series of projects that civil society organizations started paying close attention to. Social movements in the global south started paying a lot of attention to the financing of these projects. So these were the Narmada Dam, the Sardasarovar Dam in India on the Narmada River, which displaced 1 million people in India. And the Polonareste project in Brazil, which just gutted wide swaths of the rainforest at rapid speed by building highways. And these projects were done really without any rules applied. So the World Bank funded these projects without paying attention to the domestic, environmental, or legal framework. And also at that time, there were scant to no rules requiring the World Bank itself to abide by any environmental and social protections. But in response to projects like those two and many, many others like them, civil society started organizing. And groups like Environmental Defense Fund and NRDC and some of the very big environmental grassroots movements partnered with organizations from the global south and created kind of these mass social and environmental mobilizations to put pressure on the money. And as I mentioned, the U.S. is a 16% shareholder, so that the obvious tactic was to go after that influence, and that's what happened. So those environmental organizations, in particular in the U.S. and their relationships, and understood how to lobby Congress and change laws and influence U.S. policy, did just that. So first, there was a series of environmental regulations, and the main one that we have still today that's very powerful is called the Pelosi Amendment, after the leadership of Nancy Pelosi that pushed this through, creating the very first environmental rule saying that the U.S. are represented on the boards of directors of not only the World Bank, but of all the other multilateral institutions in a very similar way. That we're not allowed to vote yes and approve a project without an environmental and social impact assessment. And that was a revolution because it, for the first time, mandated that happen across the board for these high-risk projects. So the Pelosi Amendment started creating these structures for how to review projects at early stages. But the reason, again, why that was possible is because U.S. law said we're going to make sure that this happens because or else the U.S. won't fund the World Bank. So it was an extraction of a commitment from the World Bank's board of directors with a threat of not continuing the financing. So it was a direct threat of cutting off the spigot of funding. So the Pelosi Amendment created environmental policies. But very soon after, it was very clear from the civil society organizations who've done all the work to create these environmental policies and social policies at the level of the World Bank's operations that they weren't being followed. There was pretty rampant non-compliance with those rules. So many of the same organizations, and with leadership from the Center for International Environmental Law and other DC-based groups in particular, used that same strategy, going to Congress and asking Congress to pass a law forbidding Treasury from refunding the World Bank until it created an accountability office. And that was in 1993 that the very first accountability office was created because there was this demonstrated pattern, documented pattern of abuse of environmental and human rights in local communities and no commensurate compliance there are two big reasons. One is that there are so many barriers for the communities directly affected by these projects to seek justice at a domestic level. So if you think about who's being harmed by these projects, to a large degree, it is indigenous communities in Latin America, in Africa, in Asia, where there are huge obstacles to even getting information about projects. Most of the time, these projects are done without information in national languages, let alone local or indigenous languages. People don't have access to necessarily advocates who will help navigate that process, and the lack of transparency presents a barrier to even knowing who to talk to. Institutional response is another obvious barrier, and the list goes on and on and on. So that's just information. And then in terms of courts, for the domestic players involved, it's often very hard just for those practical barriers to get a construction company or a multinational corporation into a domestic court because of judicial corruption and all of the other host of issues that are barriers to local people getting access to justice in many of these countries. But then there's a whole additional barrier when you get to the level of holding the multilateral development bank itself accountable, and that's to the issue of immunity. So the World Bank has what's called immunity, for those who are not lawyers, that has to date, up until very recently, been memorialized in the federal law of countries where the World Bank operates. And in the U.S., it's the International Organizations Immunity Act, which you'll hear more about, so I won't spend time on that. But just to say that that's been the second layer of a barrier preventing legal accountability. So, in 1993, the inspection panel was created to provide the first ever citizen-driven or community-driven way for people to be heard at the level of the World Bank, recognizing that there's an accountability gap because of the immunity issue. So, the inspection panel, what did it do? It created a place for communities to directly file a complaint arguing that the World Bank failed to follow its social or environmental policies as related to one of its own investments. And that was just at the time in 1993 for the public sector lending arm of the World Bank. In 1999, there was a second accountability office created called the Compliance Advisor Ombudsman for private sector investments of the World Bank, which are through the International Finance Corporation and MIGA, Multilateral Investment Guarantee Agency. So then by 1999, the entirety of the World Bank group had, in essence, a way for communities to raise agreements and ideally to get a response through either a compliance investigation or what the CAO added, on the IFC and MIGA side, was a second feature for dispute resolution. The ability of communities to come to the table with the project operator and amicably reach a good faith agreement to resolve disputes. And the Accountability Council's role in that is that we use these accountability offices, both the inspection panel and the CAO. We've supported communities to use at their request for the last decade. And have a lot of experience we can talk about in the discussion of the outcomes of those processes. Interestingly, every multilateral development bank after the World Bank also created accountability offices. At first, it was because the U.S. made that federal policy. So every time the U.S. was voting at one of the boards of directors of the African Development Bank, the European Bank for Reconstruction and Development, the Asian Development Bank, we saw a widespread creation of these accountability offices because the U.S. could not be involved if there was not an accountability office after a certain point in the late 90s. What's been most interesting in recent years is that non-U.S.-led institutions have started creating accountability offices. So the Asian Infrastructure Investment Bank has absolutely no U.S. influence. The U.S. made a point of refusing to participate in that multilateral development bank. But nonetheless, it created an accountability office just over the past year. And I just returned from China, where the Chinese government is talking about creating accountability offices for their overseas development finance. So this is a normative shift under international law that we're seeing of having this lack of acceptance of an immunity gap, an impunity situation with development finance not being accountable. And then the Jam case happened, which has thrown everything up in the air. So I might stop my story there, where it gets the most interesting.
Wait, sorry. Michelle, I wanted to ask you next how you heard about, how you heard about Jam and what happened with Jam and his neighbors, and what your sort of initial approach was to the case at ERF.
Sure, thanks so much, and thanks everyone for being here. As I think you mentioned in the introduction, I work for an organization called EarthRights International, which is probably best known for bringing transnational corporate accountability litigation. So filing cases in U.S. courts against corporations, often extractive companies, for abuses that take place outside the United States. And typically we represent communities who have had their human rights violated or seen large-scale destruction of the environment in which they depend for their livelihoods. And one of the things that we have noticed over many years of bringing these types of cases is that these large-scale projects where these abuses tended to arise often came and were originally made possible thanks to funding from a lot of these large institutions that Natalie was talking about. The IFC in particular is the sort of arm of the World Bank that focuses specifically on private companies. So providing loans directly to private companies to enable projects that otherwise, in theory, wouldn't be able to go forward. So it was a trend that we were already seeing, and a lot of our colleagues at other advocacy organizations came to us and said, can we do anything about this? Are there legal strategies that can be used with these institutions when they plainly had this negative role in allowing, enabling, and facilitating these harmful projects that result in devastating consequences for often the very people who are supposed to be the beneficiaries of these institutions? As Natalie said, IFC, World Bank, a lot of these organizations, their central mission, their central focus is supposed to be on sustainable development and poverty reduction. But time and again, unfortunately, the people who bear the cost of those projects and those efforts are the poorest, are the people who have the least to lose. And it was obvious that there was a lack of accountability even with a lot of these mechanisms, which have played a really important role in bringing people to the table and enabling conversations to happen that weren't otherwise happening. There was a very clear lack of consistency in terms of these great policies we're seeing on paper, but then the results that we're seeing on the ground with these projects. So we started looking at the legal issue many years ago, and we're kind of stunned by what we found. Most of the cases that had gone forward against international organizations in the past actually had nothing to do with the type of harms that arise in the cases that we usually bring. It was often employee disputes, maybe a wrongful termination case or a harassment case. But what we've seen is that most of those were coming up in one jurisdiction in the United States. Most of them were coming up in the sort of DC federal court system, which is not that surprising since most of these institutions are headquartered there, and that's typically where you would bring a lawsuit against such an institution. But the result was a series of court decisions that had essentially found that the institutions like the IFC had absolute immunity from lawsuits of any kind, no matter how harmful their conduct, no matter how illegal. And looking into this, we were kind of stunned. How could it be that any institution or any person has that level of immunity at this point? I mean, no, there's nothing comparable for anyone else. And we started looking at the cases, and we saw that actually the decision was wrong. It wasn't just that we thought it was problematic from a policy perspective. We actually thought that the court had gotten it wrong. We got the legal issues wrong. We misunderstood some of the underlying problems. And it seemed to us that there was really something there that could be done. And around the same time, colleagues at other organizations had actually brought to our attention a very specific project. This is the project that led to the Jam case. It's the Tata Mundra Power Plant project in India, in Gujarat, which is a massive coal-fired power plant. And community representatives were in town as part of the World Bank's meetings, trying to meet with officials there and advocate for an improvement in the situation on the ground. And we ultimately met with them and learned more about their particular struggle. And we learned about the impacts that they were suffering. IFC, when it first considers investing in a project, puts forth essentially an overview of what the risks are, what the harms are, and what could go wrong. And they pretty plainly said, well, if we don't manage this right, if the risks aren't properly addressed and mitigated, this is going to have devastating, irreversible impacts on the community and the environment. But then they went ahead with the loan and they didn't take those steps to identify as necessary it was pretty plain from their own documents that this is the case. This community had decided to file a complaint with the Compliance Advisor Ombudsman, which is the internal accountability mechanism that was set up for the IFC specifically. And in it, they raised all the harms that they had suffered. They raised the impacts that they were already experiencing from the coal dust pollution, air pollution, from the devastating impacts construction had on their historical fishing grounds, the impacts of the cooling system, the thermal pollution that would destroy the local marine environment that they rely on. And the CAO ultimately went and they investigated and they looked into these complaints and they said, yeah, the IFC really messed up here. And they ultimately issued a report that was extremely critical of the IFC's approach, both in terms of the decision to go in the first place, as well as the inadequacy of the due diligence process, the failure to take into account what should have been pretty obvious risks. They also found fault with the way that they supervised the project, noting the influence that they have over the way a project is actually carried out. So the community finds this report, right? We get this amazing report that says everything you complained of is right, and it says IFC needs to take remedial action. So what happened? Nothing. IFC said, well, okay, we disagree. And then that was it. And the problem was this mechanism had the power to investigate and to look into it, but it didn't have the power to actually compel any action. So with nowhere else to turn, that was when we entered the picture. And we started talking with this community. We went and saw for ourselves this power plant, saw the impacts that it has had, and ultimately decided that this was a good opportunity to try to challenge the community, to try to show the court that the decision had been wrong along the way. Admittedly, most people told us that we were crazy when we started doing it. For the lawyers in the room, there was very, you could say, clear precedent against allowing a suit like this to go forward. But we knew we would have to lose a few times before we got there, so that wasn't too surprising for us. But, I mean, maybe we'll let Jeff take it from here, but I'll just say at the first level, we lost pretty quickly. The court didn't even give us oral argument in the case because it thought it was so clear-cut. It said, you know, there are decisions out of this court that say the institution has absolute immunity, so there's nothing it can do. At the appellate level, we got a similar result from the majority, but we did have a dissenting judge from a 3-judge panel who said, this is our precedent, but it's clearly wrong. This isn't the right decision. This isn't how I would rule if I had the ability to rule differently. And so from there, we took it up to the Supreme Court to try to get around that decision. So.
Great, that's a perfect segue. So Jeff, I would love to hear about how you petitioned and argued this case and what you thought were the sticking points and what you think are some of the legal implications of the decision that you ended up getting.
Sure. Well, thanks for inviting me to be part of this. It's always a particular thrill when you get to be part of the panel. It's a bit of a victory lap. You always get those things, so that's really great. And more than anything, though, I think Michelle and her colleagues deserve just an enormous amount of credit for the Jam case. I think she only gives you the barest of thumbnail sketches as to all the work that they've done in so many ways. And I'll just emphasize one, just kind of tee up the Supreme Court conversation, which is, you know, this lawsuit was brought in the teeth of precedent that said they were wrong and they didn't have a right to bring it. The D.C. Circuit, which is the Court of Appeals, the court right beneath the U.S. Supreme Court has said 1998 unequivocally these organizations have absolute immunity. And so to have the foresight and the courage and just the stamina to bring a case like that, I think it's just an incredible testament to Michelle and her colleagues. And so, you know, I was kind of the guy that got one at only the last stage. And in some ways, my job, I think, was just to sort of be a translator in a way from like all of the knowledge and information and arguments that Michelle and her colleagues have worked up to this particular forum of the United States Supreme Court that decides cases in a certain way and kind of help best package up the arguments for hopeful success in the United States Supreme Court. And guess one way to frame that challenge is how do you bring a human rights case against big financial interests in a Supreme Court that is not terribly sympathetic in general to those kinds of claims. And so that was essentially, I think, for me, the challenges that went into the court. And so I'll say three things about the way we're trying to work through this. So the first was, and I know we have a mixture of lawyers and non-lawyers in the room, so I'm not going to get too deep into any of the legal arguments. But I don't think we've actually told you precisely what the statute said in this case. The International Organizations and Immunities Act says that international organizations are entitled to, quote, the same immunity, those are the key words in the statute, the same immunity as foreign states enjoy. And so that's what the statute says. Now, the statute was passed in 1945 at a time where foreign states did have virtually absolute immunity from lawsuits. And the legal question in the court was whether the statute meant to lock that version of immunity in place, or instead, when it said the same immunity as foreign states, basically set in a evolving standard that would evolve as the immunity for foreign states evolved. And so as we sit here today, ever since 1976, it's been clear that foreign states still generally are immune from suit, but are not immune when it comes to commercial activities in which they engage. And the basic reasoning there is that when a foreign state does the things that only governments do, maybe they're immune in that situation, but if they step into the commercial marketplace and start acting like corporations or banks or whatever, then maybe they should be treated by the same rules that all other participants in the commercial enterprise are judged by. So that's the basic idea, and that's what we argued in Jam. So the first thing that we did in the Supreme Court, and this is funny, I forgot it was Halloween, so of course there were many jokes about how we're going to dress for the occasion. I decided to wear a suit. But the other thing that was going on in the Supreme Court, remember, was we just had a very, very contentious confirmation process. And in fact, Justice Kavanaugh, who was on the court at the time we argued, was recused from the case because he'd been on the D.C. Circuit at the time the D.C. Circuit decided this. But the point is, for this room, I think, we tried to approach the court understanding that the court itself as an institution had just been through sort of a very, very heated public debate about its legitimacy and about its decision-making. And so our reaction to that was to try to form arguments that were very, very legalistic and cross-cutting in their terms. And so we just said, look at the plain meaning of these words, the same immunity has, and how do we understand that? Well, today, the same immunity would mean that they're generally immune, but not for commercial activities. And so we formulated arguments just based on, so whatever your politics are, whatever your ideology are, just look at the text of the statute and construe it according to the plain meaning of the terms, and something called the reference canon of construction, which is an old tool of judicial construction the Supreme Court had never explicitly recognized, but had a lot of tradition attached to it that said you read statutes like this in this manner. One of my favorite examples from our brief was the 1866 Civil Rights Act, passed right after the Civil War, gave African Americans who were then newly freed slaves in many parts of the country enjoyed the same rights and privileges as white citizens. And so we asked rhetorically, did that mean that black people today have no greater rights than white people had in 1866? Or do they have the same rights as white people have today? And so the same analogy we applied to our argument and said, whatever you think on a broader policy level, just if you're going to be a court and interpret the words of the statute according to their meaning, you should go with us. The second thing that we did, and I'll just mention this quickly and maybe go come up with a conversation later, was we basically lobbied the Department of Justice to file a brief on our side of the case, happily and successfully lobbied the Department of Justice. Over the years, the State Department and the Department of Justice in a couple of court filings had taken the position that the IOIA should be read in the dynamic way we were proposing. But that didn't guarantee that it had to take that position in the Supreme Court in a way that it had never taken the position before. But happily, the Trump administration and the folks from the State Department and the Department of Justice we met with ended up filing a brief that was basically, on this particular aspect of the case, in total agreement with us, which I think gave some comfort to the justices at the State Department and the political branch was with us. And then finally, we had to kind of work through what I call the "it's going to be okay" problem. What if we open these floodgates and now lawsuits can be brought against these organizations? You have to give a measure of assurance to the court that opening up this new window is going to be something that's going to be manageable. And so a few things we stressed there were, and I think I'll pick up on a thing Michelle laid down about what immunity means, which is immunity means you are above the law. Immunity means you cannot be sued for anything, no matter how egregious, no matter how illegal, no matter how badly somebody is harmed, etc. And so it doesn't seem like a lot to ask to say, look, all we're asking is for them to be treated like everybody else, foreign states and other banks that would be involved in a transaction like this. We're not asking for anything dramatic, just that basic level of accountability. And then the other thing that I think we told the court, which I think maybe go into the conversation later, is, and then once you have that legal accountability, it doesn't mean that you necessarily have all these lawsuits, because what that can produce is compliance and self-governance on the front end in a way that prevents lawsuits. If you know you can be brought to court, you're going to act differently on the front end. So I've been so interested to hear, stories about reactions within the IFC and other international organizations to this case, and in a way that doesn't sort of have more litigation at all. It just has better actions on the front end. And then the final thing that I think is really fascinating to talk about is one thing we did is we looked how international organizations were treated throughout the world, and it was interesting. It was a bit of a patchwork across the globe as to whether organizations like the IFC had absolute immunity or something less. And I think that this is accurate, but my take on this was, at the time we went to the Supreme Court, the United States was basically the most restrictive possible regime, which is you never could sue these organizations, basically, ever. And very few countries have that system. But now, moving all the way over to you can be sued for commercial activities, the United States has gone from sort of the most restrictive, maybe the most permissive, in terms of when lawsuits can be brought. Many countries in the world kind of fall in some middle ground there, and I think that's one thing I'm particularly interested to hear about from people on the ground, is that how this Jam case is being digested by other countries and being folded into the way other countries in the world have approached this problem. They're all stuck.
Thank you. Okay, that's a great segue to ask Kendra. So I was interested in what the reaction of the NGO community and also the multilateral development bank community that you engaged with, what their reaction to this case has been, and what you kind of see as some of the sort of the immediate implications moving forward.
Yeah, that's a great segue as well. I would just start by saying that all of the boards of the major multilaterals have talked about this case, at least from what we've heard from the Asian Development Bank to the Inter-American Development Bank to the European-based European Bank for Reconstruction and Development based in London. So this is actually this is a great time to have this conversation. It's very live. I think just in terms of setting the stage for where we sit in Washington and kind of in the advocacy space to improve the accountability frameworks within these institutions, there's a number of things going on. So right now, just kind of thinking, stepping back from the case itself, you have new leadership at the World Bank. There's a new president of the World Bank. It's an American from the Treasury Department. You also have an institution, the International Finance Corporation, that has been found over and over and over again to have ignored the findings through a variety of cases of the compliance advisor ombudsman, the same mechanism, accountability mechanism that the fisher people had used in the Jam case. We actually have a live case right now, a case in India involving tea workers in Assam, India, and the CAO, this mechanism, found 90 pages worth of non-compliance, and the institution has sat by and done nothing in response to what the CAO has found. And this is just, the tip of the iceberg. You have that going on, the institution seeing that, okay, you've cracked the window or the door in terms of immunity here. Of course, it doesn't mean like down the road in a year or 5 years that communities are going to be able to easily bring cases against the ISE, but the lawyers there and the board they're certainly looking at this as, you know, we've not been really doing much in response to community concerns. Now we've got this court case going on, we've got new leadership, we've got competition from other institutions that are kind of coming up on the international scene. Natalie mentioned the Asian Infrastructure Investment Bank, Chinese influence, particularly in Africa and Latin America. We have a new U.S. Development Finance Corporation, which will be launched in October. So that's another multilateral or bilateral that will be, you know, coming up to compete with the International Finance Corporation and the World Bank Group in general. And then also you have just a lot of different turmoil and actors at these boards. You have the Americans still very strongly in favor of accountability frameworks, Europeans as well, and kind of a mix of pros and cons and allies and opponents within kind of the borrowing country framework that we generally think of, the Latin American countries, African countries, India and China playing pretty important roles in the dynamics here. So a lot of shifting forces, but it kind of comes down to the question from a complainant's point of view, would I sue or wouldn't I sue? If you have the option of going and using one of these mechanisms, not exactly resource-free, but compared to finding a U.S. attorney and working through the court system and spending many, many years and lots of money on trying to seek redress, which is not guaranteed through our court system, or do you use one of these community-driven mechanisms like the compliance advisor ombudsman to try to seek redress, compensation, or some kind of dispute resolution agreement that could resolve the problems on the ground. So within this context, realistically, from what we're hearing from the communities we work with, and just thinking about it in our own shoes, probably would go for the CAO option as opposed to going for the courts. Not always in every case, obviously, but so this floodgates question that's come up again and again, we've had conversations with communities and within the NGO space, really, even with the door open a little bit, it's going to be okay. There isn't going to be this floodgate. I think that's our prediction here. But it's an option, right? Having the opening there to possibly file has put a lot of pressure on these institutions to either change course and strengthen their accountability mechanisms, or, on the other hand, kind of our worst case scenario is to say, you know what, let them sue us. We don't need these accountability offices, let's just get rid of them, and then force the communities to go litigate through U.S. courts and wish for the best. So, in some ways, this is actually the live conversation, depending on who you're talking to, and all these different countries are very, it's one person or a handful of people sitting in those offices. So it's personality driven in some ways, depending on who you have in the chair, you might have a different conversation. But I continue to come back, given the context of what we're seeing right now, to the prediction that I think these institutions across the board are actually going to end up strengthening their mechanisms and their institutional responses for a few reasons. One, it's really the win-win situation for everyone involved by and large. I'm generalizing here, but for the communities, they're going to likely choose to use these mechanisms as opposed to the courts. So that gives them a win. It's a citizen-driven space for them to seek solutions. On the other hand, for the institutions, if they're in control of developing their own, accountability responses and bulking up their frameworks internally, they don't have to worry about lawsuits and the unpredictable nature of being sued in the cases that may or may not come. So it puts the ball squarely in their court to fix the problem before it gets worse. Of course, we're still waiting to see this play out. But kind of the third reason is that you have these new institutions, like Natalie mentioned, the Asian Infrastructure Investment Bank, the Chinese institutions, they're all talking about, we need one of these accountability mechanisms. No one is saying, why bother? So, the trend for the institutions like the IFC to say, you know what, this is, and it would be a major reputational blow for them just to say, you know, we don't need these mechanisms anymore, don't worry about it. So with that, and the political pressure coming still from the majority shareholders, the United States, with allies in Congress, strong players in the Treasury Department, and our allies in other countries really pushing, like, what we really need is for these institutions to be responsive. So I'm predicting, and I'm hoping, of course, that even though within the jam context, given all these other political variables or the soft variables that I'm talking about, that will continue to move in the right direction. It's kind of a second coming of the accountability frameworks where in the early 90s it was actually creating them. And now we've got a point where it's like, it's not enough just to have those frameworks, those mechanisms in place. You actually have to use them and do something about it when you find out that something's wrong. So this is a watershed moment. It's very exciting. I think it's going to go in our direction. I hope that I'm right. Got a lot of bets on it, so we'll hope to see this play out. Fingers crossed.
Okay, well, thank you so much, Kendra. Thank you, all of you. I'm going to ask a first question, and then we'll open it up. And I just wanted to find out more from people about what kinds of reactions you received about this decision and what you're hearing, if you're in the ground in the various communities that you're engaged with.
Oh, sure. Yeah, I guess I can start.
Yeah.
By the way, I want to preface Kendra's comment that I'm asking her to do by saying that our work is to make sure that the Supreme Court's decision results in better institutional responses to their accountability offices. So while Kendra is giving credit to fate to hopefully move in the right direction, she's working hard on artists to make that so. So I want to preface that by giving Kendra a bit of credit for an enormous year of that advocacy. So yeah, sure.
I can start. I mean, just to continue, I guess, from what I'm saying. There are two actually real, very important aspects going on right now that give us kind of the opportunity to respond and to push forward community voices. So what we have been hearing is a lot of concern from the institutions themselves that we haven't been doing enough. What's been going on? We haven't been watching. There hasn't been enough oversight of the institutions, primarily from the board. You get a bit of a mixed bag from the folks in the legal department, and a mixed bag from management, where you see some and it's a broad swath here, some that are very, anxious to see what's going to happen, to people who work at these institutions actually applauding the jam decision. So it's quite a range. At the end of the day, it'll come down to the votes in terms of strengthening these mechanisms. But I think communities, by and large, our community that we're supporting in Assam, India, and other communities are excited about this opening. Whether or not they would ever use it or pursue it is another question. It's a long battle. It takes a lot of work, as you both know. And I think from the mechanisms themselves, like the compliance advisor, ombudsman, and other mechanisms, again, it's kind of a tenuous wait and see. Obviously, they would like to see the frameworks work within the institutions, to actually see that their hard work and efforts to improve the institution by pointing out, hey, this is where something went wrong. We have the opportunity to fix it. They would like to see it fixed. I mean, naturally, that's their job. And I think just lastly, as a very concrete point, there are 2 reviews or reform efforts ongoing right now. One is on the inspection panel, live. I recall in this in 2 hours, to decide, the board is working to decide, should we strengthen the inspection panel or not? Should we give the inspection panel more tools or not? And it is a live debate. There's no certainty there. I'd like to think that we have some wins in front of us on that. And then the second review is for the compliance advisor ombudsman. But the interesting thing with that, typically mechanisms will undergo a review themselves, right? It's just you're looking at the mechanism, or you change the policy, make it easier to file, what happens to their different functions. But for the CAO's review, the board has decided to expand the review to not only look at the CAO, but also to look at the entire institutional framework in which the CAO sits. So also looking at the International Finance Corporation's responsiveness to the CAO, which is a direct result of the JAM case. So there's a lot that will be happening in the next 6 to 12 months with these mechanisms to see, where is it going to come down? Are they going to be stronger, or are they going to be weaker, or somewhere in between?
Yeah, I replied to types of responses that I've seen or sort of questions that have been raised. One, following on what Kinder said, and I think perhaps one of the more interesting ones is that this decision came down the end of February. In early April, the CEO of IFC, so the head of IFC, put out an op-ed that was pretty interesting. Pretty interesting because it repeatedly used the word accountability, which is not a word that we pretty much ever heard coming from the head of the institution. And in it didn't ever point to this lawsuit directly. It did never say we're responding to this decision. But it said we recognize that there's a culture problem here. We have a problem in terms of the way that we're approaching these issues and the way that we're responding. This is something that needs to change. Accountability is essential to our mission, especially being responsive to the communities who really are the people that this institution was designed to advance, to bring out of poverty, and saying that there has to be something that changes. Part of that is the CAO review process, and it said in it, we need to figure out ways that we can be responsive from the beginning. Now, okay, these are just words, and I'm the last person who's going to assume that this actually means something until we see it in action, but it is significant, and I think it does show that there is a different calculus going on with the institution, and ultimately, changing the rules of immunity for us was essential not just for the situation of our clients, although it is an important, necessary step in order for them to eventually obtain remedies for the harms that they've suffered. But it's important to make sure that the calculus changes to prevent this from happening in other cases. So as Jeff was saying before, institutions who know that they could be subject to outside scrutiny and outside accountability act on it. When they make their decisions, when they decide whether to invest in something, whether they decide whether to buy a particular land or merge with another company, they look at it from, okay, this is a smart business decision, but also, am I going to get sued? Am I going to be subject to this accountability in courts that, may mean large financial repercussions, may mean a bad PR hit, may mean a reputational damage that's lasting? And so making sure that these institutions have that possibility in mind necessarily leads to better decision making, because you start to take into account the broader range of repercussions. So what this actually turns into, we don't know yet. I think it's still definitely early days, but to be hearing this kind of language coming out of the institution, from the head of the institution, recognizing the need for a culture change is significant. And then the other area I would say, which is maybe not as obvious, but I've actually had a lot of foreign lawyers contact me. This isn't just after the decision. Some of this outreach had happened before, but asking, so is this just a U.S. thing? Are there ways that we can be holding these institutions accountable in the countries where the harms are happening? And the answer is yes, that should be possible. It hasn't happened yet, but what's interesting is that the rules are actually different in other countries. As Jeff said, there's sort of a patchwork, but what's really interesting is the number of countries who actually don't have a separate legal framework that governs the immunities of international organizations. So our case was focused on how you interpret U.S. law. In other countries, they don't have a law that sets it out. Instead, they have sort of the founding document, the charter, if you will, that sets up the institution, incorporated into their laws. Some of those charters purport to provide immunity, but a lot of them don't, and the IFC's doesn't. So there are some really interesting legal questions that could come up in future cases if there are lawyers who are pursuing these in other jurisdictions. And finally, I would just say to Kinder's point, to illustrate what she was saying, in our case, we almost certainly wouldn't be here right now if the IFC had responded to the CAO complaint in our client's case in a way that actually tried to do something to fix the situation, that actually tried to say, okay, we screwed up, how can we try to fix it or at least minimize the damage? It's the fact that they completely ignored it that is the reason why we're here. There wasn't any other options. So in the future, maybe that will help to incentivize being responsive to these institutions. But that doesn't mean litigation is a better option. Litigation is hard, it takes forever, it's expensive, and there's a ton of legal barriers along the way that can be in a totally meritorious case loses for very technical procedural reasons. So to the extent that these institutions can provide meaningful redress, litigation will almost always be a better option. But to get there, there has to be consequences for not enabling those to actually do the job they need to do.
Well, I'll just say two very, very quick things. One is to pick up on Michelle's point about the interaction of the U.S. law-based decision with the law of other countries. Many other countries follow what's called a functional immunity test, where they ask the question, is granting immunity to this organization necessary to allow the organization to do its work? And what's interesting to this is the way different legal systems can in fact talk to each other now, so that the U.S. is now going to embark on a system where organizations, international organizations, do not have immunity for all their commercial activities. And if that doesn't end up with them having to fold their tents, then we will be able to say immunity in that situation is not necessary for them to do their work in a way that might fold into other countries' laws, which would be interesting. So the other thing I'll say is just as we talk about the various reactions to the Supreme Court case, I can't resist mentioning just the reaction of our clients, which we had a video of the party that night in India. So the Supreme Court decisions are announced in the morning in the United States, which is a very different time of day in India, and just to see the elation at the human level of just the clients in the particular case was just one of those moments for me at least that was really touching. We all have our own view of the U.S. Supreme Court, and some of us may think in sort of pessimistic ways about it. But don't tell that to our clients in this case. I think the Supreme Court is a pretty great thing, which was cool.
I mean, especially when you think about how many times they had to lose before they got to that decision. I mean, first of all, like having gone through this whole process with the CAO, where, first of all, trying to ensure the project wouldn't be as devastating from the start, but then once they go through the CAO, their first major win was essentially the CAO agreeing with them. But then they saw nothing happen, and they saw they engaged in direct advocacy with the bank, and nothing happened. And then, we decided to take the case, and then we lost at the DC District Court, we lost at the DC Circuit. We tried to have the full DC Circuit hear it en banc, which is sort of like a mini level between the appellate level and the Supreme Court. We lost, and then we went to the Supreme Court. So to finally, it really means that there are still so many steps to go, right? This is really the first issue. So whether they can even have a foot in the courtroom door is this question. So there's a long way to go before there's actually a meaningful redress for them. But to be able to sort of have their story, where they couldn't even get the bank to talk to them for so long, to have their case heard before the Supreme Court is, it's powerful, right? It gives you hope, and it's a real privilege to be able to be a part of that.
I just wanted to mention, maybe very briefly picking up on the incentive piece, that we really see this case and litigation as necessary but not sufficient to translate into changed behavior of the institutions. And I say that because after studying these institutions at the community level to see the impact on communities, it's clear that the decision-making throughout the institution, not just at an executive decision-making level, but all of the phases of the institutional decision-making is what leads to harm. And so while at an executive level there may be changes that are reactive to litigation that change the way projects are vetted and operationalized, until incentive structures are put in place for every level of the institution, we're not going to see meaningful change. So that incentive structure reform is how I see this litigation. It's part of that bigger effort to change staff compensation, for example, is based right now on lending volume. So getting loans out the door is how you get promoted and advanced within the institution, not the effectiveness of any given loan, not its result. So until that kind of thing is changed, it's going to be very hard to see meaningful, widespread reactions that change things on the ground. So that's part of this root cause initiative that we're working on of taking advantage of the litigation, putting it in this bigger picture set of reforms that are required.